Sige, let us continue with our uh, discussion. And today, or this session, we will be discussing Rule 115 and Rule 117. Okay? So, i-connect natin yan siya because Rule 116 and Rule 118 are very related na yan siya under the continuous trial. So, isahin natin ang pag-discuss ng Rule 116 at saka Rule 118. Rule 115 and Rule 117 will be discussed under this session. Okay, so let's start with Rule 115. Actually, this is just an enumeration of the rights of the accused during court proceeding. Iba ito sa Miranda rights na napagdaanan natin because Miranda rights are those rights observed during the arrest. Okay? Whenever the accused or the person is arrested, then the arresting officer must remind the arrested person or the accused that he has these following Miranda rights. Okay? This time, ang Rule 115, ito yung rights ng accused in the court proceedings na. Okay? So, it says there that in all criminal prosecutions, the accused shall be entitled to the following rights. Una, to be presumed innocent. Okay? Remember that the presumption is to make the fight at least equal. In criminal cases, all the resources are directed against the accused. And it is the accused against the people of the Philippines. So you are fighting the state and the resources of state. Mere accusation is not enough to convict him, and neither is the weakness of the defense. That is why the presumption of innocence is not an automatic or blanket exoneration. It is at best only an initial protection, and if the prosecution succeeds in overthrowing the presumption, then it becomes an outlook of the accused to adduce evidence that will at least raise the inkling of doubt that he is guilty. Once the armor of the presumption is pierced, so to speak, it is for the accused to take the offense and ward off the attack. That is People versus Siqueira, October 12, 1987. So, there is this presumption of innocence, okay, until the contrary is proved beyond reasonable doubt. And who has the burden to overthrow that presumption? It is the prosecution. That is why it is the prosecution in criminal cases that has the onus probandi to overthrow the presumption. Second is that the accused has the right to be informed of the nature and cause of the accusation against him. Okay? So this cannot be waived, and this is complied. This right is complied with the court during arraignment. Okay? Okay. Now, to be present, the accused has the right to be present and defend in person and by counsel at every stage of the proceedings, from arraignment to promulgation of the judgment. The accused may, however, waive his presence at the trial. Yan yung tinatawag nating trial in absentia. Waivable right yan siya. Pursuant to the stipulation set forth in his bail, unless his presence is specifically ordered by the court for purposes of identification. And when does this happen? During arraignment and the and promulgation of the judgment. Okay? So the absence of the accused without justifiable cause at the trial of which he had notice shall be considered a waiver already of his right to be present there. Because this right under number 3 is a waivable right. When an accused under custody escapes, he shall be deemed to have waived the right to be present on all subsequent trial dates until custody over him is retained. Upon the motion of the accused may be allowed to defend himself in person when it sufficiently appears to the court that he can properly protect his right without the assistance of counsel. But this is highly discouraged, that the accused will do it alone. Okay? So, yeah. In the case of Careto versus People, the Supreme Court said here that waiver of appearance and trial in absentia does not mean that the prosecution is thereby deprived of its right to require the presence of the accused for the purpose or for purposes of identification by its witness, which is vital for the conviction of the accused. Okay? So, where the accused appears for trial without counsel and his motion for postponement was denied, is the court required to appoint counsel de officio for him? The answer is no. The duty of the court to appoint counsel de officio is only mandatory at the time of the arraignment and not during the trial. Please take note of that. It is the case of Sison versus People. What else is the right of the accused in the court proceedings? To testify. Okay? The accused has the right to testify as a witness in his own behalf, but subject to cross-examination on matters covered by the direct examination. The accused silence shall not in any manner prejudice him. Also, he has the right to be exempt from being compelled to be a witness against himself. Okay? This is the right against self-incrimination. Okay, so to be exempt from being compelled to be a witness against himself. Another right is to confront and to cross-examine the witnesses against him at the trial. So meaning to say you cannot deprive the accused of being there during the presentation of the prosecution's witnesses. Okay? Because that is his right to confront all the witnesses of the prosecution. Either party may utilize as part of its evidence the testimony of a witness who is deceased, out of or cannot with due diligence be found in the Philippines, unavailable or otherwise unable to testify, even in another case or proceedings, judicial or administrative involving the same parties and subject matter, the adverse party having the opportunity to cross-examine. Okay, so yeah, what are the other rights? The right of the accused to have compulsory process issued to secure the attendance of the witnesses and production of other evidence in his behalf. So here, the accused may ask for a subpoena, for the issuance of subpoena from the court para makumpeli yung attendance ng kanyang witness na gusto niyang i-present. Okay? The accused must also have the right to have a speedy, impartial, and public trial. Speedy trial is a relative term and must necessarily be a flexible concept. Okay, there are factors that may be considered and must be balanced by the court. Okay, so like for example, the length of the delay. What else? The reasons for such delay, the assertion of failure to assert such right by the accused, the prejudice caused by the delay. So, yeah. So this is the right to have a speedy trial. Okay. Another right is the right to have an impartial trial and the right to have a public trial. Sa speedy trial, if palaging absent yung prosecution or yung witnesses ng prosecution and this is violated, then the accused may invoke this, and upon the invocation of the accused, the court may dismiss the case for violation of the speedy trial, the right to speedy trial. Okay? So the judge may exclude the public. Okay? When it comes to public trial, Rule 119, Section 21, i-advance natin ha. The judge may exclude the public from the courtroom motu proprio if the evidence to be produced during the trial is offensive to the decency or public morals, or on the motion of the accused except court personnel and the counsel of the parties. Okay? The accused also has the right to appeal in all cases allowed and in the manner prescribed by law. Okay? So those are the rights of the accused in the court proceedings. Should you memorize it? I will guarantee or I will recommend that you memorize the rights of the accused during the trial. Okay? Rights of the accused at the trial. Okay? Class take note ha, even if the caption of Rule 115. Okay, kung titingnan mo yung Rule 115, ang caption niya is rights of the accused at the trial. But the rights there are not only observed during the trial, they are observed during the court proceedings. Okay, so meaning to say, from the time that the court already acquires jurisdiction over the person of the accused, and during the course of the proceedings, those rights are already observed, not only during the trial stage. Okay? Like for example, yung right to be informed of the nature and cause of the accusation against him, that is not observed during the trial proper, that is observed during arraignment, okay, which we will discuss later. Okay? But before we go to arraignment and pre-trial, let us discuss Rule 117. Okay, Rule 117 is not part of the court proceedings, but it is a remedy that you may consider, or a strategy that you may do before pre-trial or before arraignment. Ito yung tinatawag natin motion to quash. Okay? A motion to quash is a kind of motion. Okay? So, Rule 117, let's go. So, this is a remedy, and this is done, or this may be, you may consider this at any time before entering his plea, meaning to say before arraignment. The accused may move to quash what? You may move to quash the complaint. You may move to quash the information. In fact, you may also move to quash the information or the warrant of arrest. Kung gusto mo. Okay, basta it must be done before the arraignment. Okay? So the failure of the accused to assert any ground of a motion to quash before he pleads to the complaint or information, either because he did not file a motion to quash or failed to allege the same in the said motion, then what is the result? It shall be deemed a waiver of any objections based on the ground provided in paragraphs A, B, G, I of Rule 117, Section 3. So when I fail to file a motion to quash, then there has already been arraignment. Can I file it later? Remember, waive na yan. No, all the defects are waived. It is no longer allowed to file a motion to question it. Except na lang kung ang ground mo ay jurisdiction, or when the information does not charge an offense, or criminal liability has already been extinguished, or double jeopardy. Okay, but if the grounds are other than those four, then that will constitute a waiver if you will not timely object. In the case of People versus Rafot, GR number 169509, September 5, 2007, this is penned by Justice Tinga. Okay. So, ang sabi ng court dyan, it is unnecessary to state in the information the precise date that the offense was committed. We learned that already, diba? Except when it is an essential element of the offense. The date of commission is not an element of the offense of rape, because the gravamen of rape is the carnal knowledge of a woman under any of the circumstances provided by law. Okay. Furthermore, in this case, it is too late for the accused to raise this issue. He should have made his objection before he was arraigned. Kasi nga, yun yung implication or yung effect under Rule 117, Section 9. Okay? So, yan. Let's go to Rule 117, Section. The motion to quash shall be in writing. It's not orally made. It must be in writing. It shall be signed by the accused or his counsel, and shall distinctly specify its factual and legal grounds. The court shall consider no ground other than those stated in the motion, except the lang if lack of jurisdiction over the offense charge, okay, or the lack of jurisdiction over the subject matter. So the accused may move to quash the complaint or information on the following grounds. So please take note of that. That is Rule 117, Section 3. That the facts charged do not constitute an offense. Okay, so that's first. You can raise that even after arraignment. That the court trying the case has no jurisdiction. Okay, no jurisdiction over the offense charged. that can also be raised even the after the arraignment. That the court trying the case has no jurisdiction over the person of the accused. That the officer who filed the information had no authority to do so. That it does not conform substantially to the prescribed form. Duplicitous information. Okay. That the criminal action or liability has been extinguished. That it contains averments which, if true, would constitute a legal excuse or justification, and that the accused has been previously convicted or acquitted of the offense charge, or the case against him was dismissed or otherwise terminated without his express consent. Does a court have authority to consider and resolve a motion to quash an information even if no warrant of arrest has yet been issued and the accused has not yet been arrested? The answer is yes. Okay. In the case of Jose Miranda, okay, versus Tuliao, where it was ruled that the custody of the law is not required for the adjudication of beliefs other than the application for bail. However, while the accused are not yet under the custody of law, any question on the jurisdiction over the person of the accused is being waived by the accused when he files any pleading seeking an affirmative pleading. So, pwede yan siya i-resolve ng court. But once nag-resolve ang court, that is to say you have already submitted yourself to the jurisdiction of the court. Okay, so that is voluntary appearance or submission. If the motion to quash is based on an alleged defect of the complaint or information which can be cured by amendment, then what is the remedy here? Should the court quash? The answer is no. The court shall just order the amendment to be made. If the motion to quash is based on the ground that the facts charged do not constitute an offense, then what is the remedy here? The prosecution shall be given by the court an opportunity to correct the defect by amendment. The motion to quash shall be granted if the prosecution still fails to make the amendment, or the complainant, or if the complaint or information still suffers from the same defect despite the amendment. Now, what will happen if the information is quashed? The answer is found in Rule 117, Section 5. The court may order that another complaint or information be filed except as provided in Section 6 of Rule 115. If there is an order that another information or complaint be filed, then the accused, if in custody, shall not be discharged unless admitted to bail. If there is no order that another information or complaint be filed, or if there is an order but no new information is filed within the time specified in the order or within such further time as the court may allow for good cause, then the accused, if in custody, shall be discharged unless he is also custody for another charge. This is not a bar to another prosecution for the same offense unless the motion was based on the grounds specified in Section 3G or Section 3I of Rule 115. Okay? As a rule, all other grounds for motion to quash, even if granted, will not really be a total victory for the accused. That is why some lawyers will never bother to file a motion to quash anymore. It's because once you file it, the same case will be refiled. Okay? And there is no violation of double jeopardy. As a matter of fact, there are cases when it is not advisable. Okay? So, yeah. In the case of Gonzalez versus Salvador, GR number 168340, December 5, 2006, penned by Justice Carpio, the Supreme Court here says that Rule 115, Section 4 covers, or Rule 117, Section 4 covers the amendment of an information. Section 5 deals with the filing of a new information. Once the court issues an order granting the motion to quash the information, and such order becomes final and executory, however, there is nothing more to amend. Okay? So, what else can be quashed aside from an information or a complaint? You can also quash the warrant. It could be the search warrant or the warrant of arrest. You can quash that. In fact, you can also move for the suppression of the evidence. We learned that when we discuss about MUC6. Question from the class. So again, you have to file that before arraignment. Okay. Question from the class. Wala. Okay. So the next hearing or the next case. Provide us. So the next case here or the next topic that we are going to take is yung last na topic para sa midterm coverage. Ito yung arraignment and pre-trial. Should you have any questions, please feel free to raise your questions before the exam. Meron tayong mga clarifications. The table is open until before the exam begins. Okay? So God bless everyone and have a